Hi, welcome to my YouTube channel Legal Voyage. Today I wish to discuss a brief introduction to the law of delict. Let us first see the definition of a delict. A delict can be defined as the breach of a duty imposed by law independently of the will of the party bound, which will ground an action for damages at the suit of any person to whom the duty was owed and who has suffered harm in consequence of the breach. Let us break this up into pieces and study. So, what is a delict? A delict can be simply said as a breach of a duty imposed by law independently of the will of the party bound. As a fact, we all know when a law imposes a duty upon us, we would be bound by it independently of our will. So, whether we like it or not, we would be bound by it. So, when a person breaches a duty that is imposed by law upon him, he is said to have committed a delict. Let us now see an example. Adam, while driving his car, knocks Amy down. In this instance, Adam is in breach of his duty to drive carefully on the road. Therefore, Amy, who has suffered injuries as a result of Adam's negligent driving, can go to courts and claim damages under the law of delict. Also, Adam will face criminal prosecution for his negligent driving under the road traffic laws. So, what are the consequences of a delict? A delict will ground an action for damages at the suit of any person to whom the duty was owed and who has suffered harm in consequence of the breach. With regard to the example that we just saw, Amy, the person who has suffered harm in consequence of Adam's breach of duty, can go to courts and claim for damages. So the consequence of a delict is simply an action for damages. What are the two types of delicts? The law of delict identifies two specific types of delicts. These are damnum injuria datum. This means a delict which causes a pecuniary loss to another. A pecuniary loss means a monetary loss or a financial loss. The other type is injuria. Injuria means a delict which causes a sentimental loss to a person. A sentimental loss means a wrong committed against a person's personality, dignity, or reputation. So let's see the two types of actions available for the two different types of delicts. Firstly, for damnum injuria datum, the type of action available is called an acquidian action. This means a person who suffers a financial loss as a result of a delict should go to court and claim damages under an acquidian action. On the other hand, a person who suffers an injuria, that means a sentimental loss, should go to court and claim damages by way of actio injuriarum. These two types of actions are called the foundation stones of law of delict. Let us now distinguish a delict from a crime. A crime is a wrong prejudicial to the public interest. The primary object of a criminal prosecution is to punish the accused. In the case of Adam, when Adam breaches his duty to drive carefully on the road, he is committing a wrong which is prejudicial to the public at large. Therefore, as I said, he will face criminal prosecution under road traffic laws and he will be punished for his offense. On the other hand, a delict is a wrong prejudicial to an individual. The primary object is, therefore, enforcement of a right claimed by the plaintiff against the defendant. In the case of Adam and Amy, Adam has committed a civil wrong against Amy. Therefore, Amy will go to courts and claim for damages. In that instance, the law of delict will not punish the accused. It will only enforce Amy's right to claim damages. As said by Macaron, every delict is not a crime, but every crime is also an actionable wrong. Therefore, crime and delict are regarded as complementary, not mutually exclusive. As an example, theft, assault, negligent driving. All these give rise to civil as well as criminal prosecution, but it does not mean that every delict is a crime. Now we know how to distinguish a delict from a crime. The next is to distinguish a delict from breach of contract. Breach of contract is a breach of a duty voluntarily assumed by entering into a contract. For example, in commercial contracts, two or more parties may enter into a contract on their own terms, and if one of the parties breach one of the terms in the contract, it may amount to a breach of a duty. In such an instance, the burden of disapproving negligence is on the defendant. On the other hand, a delict, which is a breach of a duty imposed by law independently of a contract, the burden is on the prosecution to prove negligence. In the case of Adam and Amy, when Amy go to courts to claim damages from Adam, she has to prove that Adam was negligently driving. Some of the acts or omissions may be both a breach of a contract and a delict. For example, a surgeon causes harm to a patient he operates by negligently leaving a surgical swab inside his body. In this instance, it may amount to both a breach of contract and a delict. Let's see how the cause of action arises in both contract and delict. The cause of action in contract is an implied promise to use due care in performing the surgery. A surgeon who performs a surgery is voluntarily undertaking to exercise due care and diligence. Therefore, if he leaves a surgical swab inside his patient's body negligently, it amounts to a breach of a duty that he has voluntarily undertaken. That means it is a breach of a contract. On the other hand, in delict, every person is under a duty to use care and not cause physical injury to others. This means a surgeon who fails to exercise due care and diligence is also committing a delict. Thank you for watching the video. My next lesson will be on Aquarian action. Subscribe my channel for more lessons on legal principles. Thank you.